Data protection laws in selected African countries. An overview. Algeria. Algeria's Law No. 1807, enacted on 10 June 2018, focuses on the protection of natural persons in personal data processing. The law defines personal data and sensitive personal data with specifics on racial, ethnic, political, religious, and health-related data among others. Although the establishment of a national data protection authority is stipulated, it has not yet been operational. Any data processing requires prior declaration or authorization by this yet-to-be-established national authority. Angola. In Angola, the Data Protection Law, Law No. 2211 of 17 June 2011, alongside the Electronic Communications and Information Society Services Law, Law No. 2311 of 20 June 2011, govern data privacy and protection. Personal data is broadly defined, and sensitive personal data includes information on philosophical or political beliefs, religious beliefs, health or sex life, among others. The Agência de Proteção de Dados, APD, acts as the National Data Protection Authority. Data processing activities require prior notice or authorization from the APD. Botswana. Botswana's Data Protection Act, Act No. 32 of 2018, effective from 15 October 2021, aims to ensure individuals' privacy concerning their personal data. The Information and Data Protection Commission oversees the Act's implementation, ensuring compliance with the right to personal data protection. Personal data includes identifiable information about an individual, while sensitive personal data covers racial origin, political opinions, health conditions, and more. Egypt. The Personal Data Protection Law No. 151 of 2020 in Egypt covers any data related to an identified or identifiable natural person. Sensitive data encompasses a broad range of data including health, genetic, biometric, financial data, religious beliefs, political views, and data concerning children. The Personal Data Protection Center, under the Minister of Communications and Information Technology, enforces this law. Ghana. Ghana's data protection is governed by the Data Protection Act, 2012, Act 843. The Act requires data controllers to register with the Data Protection Commission. While there is no specific requirement for data protection officers, data controllers can appoint a certified data supervisor to monitor compliance with the Data Protection Act. Kenya. The Data Protection Act, 2019, is Kenya's primary statute on data protection, complemented by several regulations and guidelines for implementation. The Data Protection Commissioner, DPC, oversees the enforcement of these laws. Personal data in Kenya includes any information related to an identifiable natural person. Nigeria. Nigeria's Data Protection Act, receiving presidential assent on 13 June 2023, aims to protect personal information and establish the Nigeria Data Protection Commission. The Act covers a wide range of objectives including safeguarding personal data, promoting data processing practices, protecting data subjects' rights, and supporting the digital economy. South Africa. The Protection of Personal Information Act 4 of 2013, POPIA, in South Africa came into effect on 1 July 2020, providing a detailed definition of personal data. The Act applies to the processing of personal information entered into a record by or for a responsible party that is domiciled in South Africa. Tanzania. Tanzania's Personal Data Protection Act, 2022, came into force on 1 May 2023, establishing principles for the collection and processing of personal data. The Act also outlines the creation of the Personal Data Protection Commission, responsible for the Act's implementation. Uganda. The Data Protection and Privacy Act, 2019, supplemented by the Data Protection and Privacy Regulations 2021, regulates personal data collection, processing, use, and disclosure in Uganda. The Personal Data Protection Office, operational since August 2021, enforces these regulations.